Welcome, everybody. Welcome and thank you for attending this webinar. My name is Julie Berg. I'm the Director of the Scottish Centre for Crime and Justice Research. And just to indicate that I've started recording this webinar, you would have received that message already. And we put our webinars up on the Scottish Centre for Crime and Justice Research YouTube page, so you'll be able to look at that after this webinar. So firstly, just to say that this webinar is part of a series of webinars called Security and Justice Futures. And it is being offered as a collaboration between the Scottish Centre for Crime and Justice Research, the National Crime Research Centre in Kenya, the Global Risk Governance Programme at the Faculty of Law, University of Cape Town, and the Institute for Development Studies at the University of Nairobi. And so this is, I think, the fourth webinar in a planned series. It'll go on into next year as well. So I'm very pleased to have Danielle with us. And Danielle Watson is an associate professor. She's a senior research fellow in the School of Justice, Queensland, University of Technology. She co-leads QUT's Indo-Pacific and Small Island Security Governance Research Group. She's an adjunct associate professor at the University of the South Pacific and an affiliate of the Resilient and Sustainable Islands Initiative. So Danielle and I have worked together, and been very good experience for me, at least. She conducts research on insecurity in small island developing states, capacity building for security service providers, policing culturally and linguistically diverse communities, and plural regulatory systems and other areas specific to improving security governance and, I would say, justice in developing country contexts. So Danielle has contributed significantly on this topic, particularly on small island developing states in the Global South. And I think her talk today is testimony to her absolute in-depth knowledge of how non-state systems function in these contexts. And I'm sure a lot of us could learn from that. I mean, it's not that it's just focused on Pacific Islands, but I think there's a yearning in the search for alternatives to traditional systems of justice. And I think Danielle will speak to that today. So we only have Danielle today. I mean, usually we have two speakers, but Danielle, I think, will spend some time on this topic. I think about 30 to 45 minutes. I think it's it's a very fascinating talk that she'll be giving, I'm sure. And we'll have some questions in the last 15 minutes or so. So I'd ask you to please just stay muted and maybe switch your videos off during Danielle's talk. There's a chat function if you want to put questions in the chat while she's talking, but we'll have questions at the end. So thank you again for attending, and I hand over to you, Danielle.
Thank you so much, Julie. Thank you for the introduction, and allow me to say I also enjoy working with you and look forward to continuing to work with you. Let me just share my screen.
Great. Okay, perfect.
Okay, it's
all good to go.
Julie already introduced me. I would not say more other than the fact that I am the majority of my focus today would be on the Pacific Island, and I speak from a position as an outsider. I am a Caribbean island, but my perceptions do not necessarily represent the views of Pacific Islanders. I'm just gonna have a talk or a brainstorm about rethinking what we know about access to justice and draw on a case study from the Pacific to substantiate my views on why we need to rethink access to justice. Allow me to begin with situating this conversation or this chat within a larger body of work. So I'd like to draw attention to the UN Sustainable Development Goals. So in 2015, Pacific Island nation signatories to the UN committed to addressing sustainable development challenges as outlined in the UN's General Assembly 2030 agenda. Now, the agenda included 17 goals identified as necessary to transform the world and achieve a better and more sustainable future for all. Each of these goals were premised on the identification of a specific global challenge, and each challenge was unpacked based on international, or some might argue, mainstream understandings of what the challenge entailed. And based on this understanding, a specific list of targets relevant to each goal was identified and, of course, prioritized for addressing by the year 2030. Now, the focus of my talk today is underscored by Sustainable Development Goal 16, Peace, Justice, and Strong Institutions, and transitions towards the actioning of this strategic goal in the Pacific context. Though more than 10 years have passed since countries have committed to actioning these goals, reports on transitions towards peace, justice, and strong institutions coming out of the Pacific remain few and far apart. It is, however, important to note that there is a lot of work being done across the region that speaks directly to the meeting of the outlined goal, though it's not recognized as being aligned to meeting the target. Now, when we look at unpacking access to justice, or justice dialogue in general, there have been attempts to define concepts of access to justice. In a very general sense, access to justice is recognized as the basic principle of rule of law. If we look at the Law Council of Australia, it's described as getting the right information about the law and how it applies to individuals, understanding when individuals have a legal problem and knowing what to do about it. It looks at getting the right help, again, with a legal problem, including help from a lawyer, and being able to deal with your legal problem and understand the outcome. It also looks at making sure your voice is heard when laws, again, are made. Definitions coming out of the US, the United Kingdom, Canada, basically converge in their descriptions of access to justice as entailing normative legal protection, legal awareness, legal aid and counsel, adjudication, enforcement, civil society oversight, amongst others. Such definitions basically cater for constraints and obstacles confronting the justice delivery system, which could include, but are not limited to, long delays in adjudicatory processes, long adjournments of proceedings, over-reliance on technicalities, collapsing infrastructure, corruption, congestion, poverty, and all of these issues around the administration of justice. What we can all agree on is the fact that access to justice means different things to different people in different contexts. In its narrowest sense, it represents only the formal ability to appear in court. Broadly speaking, it engages the wider social context of court systems and the systemic barriers faced by different members of the community. The UNDP's 2004 practice note on the subject, going beyond mere access to institutions, deals with access to justice as a process leading from grievances to remedy and requiring legal protection, legal awareness, legal assistance, adjudication of disputes, enforcement of remedies, and oversight of the operation of the system. Now, if we further examine descriptions of access to justice from around the globe, we will find more of the same. By the same, I mean descriptions grounded in Western statutory frameworks that are non-cognizant or unclear on the place of local or non-state justice frameworks, even at the UN level, where attempts have been made to responsibly acknowledge the existence of such frameworks, the descriptive conundrum endures. Now let's switch focus to the Pacific. Despite the existence of acts which acknowledge local Pacific justice frameworks, such as the Falikapule Act in Tuvalu or the Village Fono Act of Samoa, descriptions of access to justice found within legislations in these Pacific Islands remain very Western-centric, with unclear and oftentimes very brief mention of how such acts remain subject to interpretation under the legislation of the land. It is also not uncommon for issues of access to justice to be presided over in the Pacific at local levels to come into direct conflict with state legislation as outlined in the country's constitutions, or for rulings to be deemed invalid, unconstitutional, or unjust. Now, I have no delusions about being able to solve the descriptive conundrum that has and continues to perplex scholars and practitioners far more advanced in knowledge and experience than myself, an early career academic from a third world small island developing nation in the English-speaking Caribbean. Instead, my intention is to look at expanding dialogue on access to justice in the South Pacific by acknowledging the forced-to-fit nature of unadapted external descriptors, and looking at ways of indigenizing how access to justice is conceptualized to basically aid in transitions towards the accomplishment of SDG 16. Now, in order to do so, there needs to be an understanding of the Pacific, or more specifically, an understanding of multi-island jurisdictions. Now, while there are several areas specific to understandings of multi-island jurisdictions, I believe there are 4 key areas relevant to discussions about the Pacific. Now, when you listen to most persons talk about the Pacific, there is a tendency to make reference to small islands. But if we put the Pacific into perspective, what exactly does that mean? Now, the World Bank's Pacific Island member countries have a combined population of about 2.3 million people, spread across a unique and diverse region made up of hundreds of islands, scattered over an area equivalent to 15% of the Earth's surface. For many of these countries, jurisdiction is spread across multiple remote islands with limited means of accessibility. Take, for example, Kiribati, a Pacific Island state. Kiribati is one of the most remote and geographically dispersed countries in the world. It consists of 33 coral atolls that are spread over 3.5 million square kilometers of ocean. This is an area larger than India. For these multi-island jurisdictions, state justice mechanisms are limited to densely populated areas or capital cities primarily, with little to no state presence in sparsely populated areas. I'll return to this point a bit later. Now, interface with colonial powers and historical complexities have and continue to shape Pacific Island jurisdictions to date. Lessons learned by colonizers in the Caribbean basically meant a less brutal and less aggressive colonization of the Pacific, greater interface with Christian missionaries, and Christianity also resulted in a more purposeful Christianization of the region. Now, this interface translated to colonial policing imports, which continue to evolve and adapt to local circumstances, with some countries having more success than others. The National Democratic Institute describes the 12 sovereign nations forming the Pacific Island region as characterized by young democratic governments. The governance systems of the Pacific Islands need to be understood in their cultural context, one that has historically placed high value on kin connections and kin loyalty and distribution of power, wealth, and opportunities according to these principles. Very un-Western, if I might add. For many Pacific Island countries, the state as a modern form of political organization basically came with colonial rule. Now, after a century or so of colonial administrations, when the foreigners departed, leaving behind a Westminster or American presidential system of governance, this system had only been introduced to the Pacific Islanders in the last few years before independence, and was supposed to run along Western lines after independence. It is important to note that Pacific Islanders soon adapted these imported systems to their own expectations and assumptions, creating the contemporary form of island governments we see today. Now, the imported and adapted systems of governance work better in some countries, such as Fiji and the Polynesian countries, than elsewhere in the Pacific region, possibly because they were superimposed on hierarchical societies and after long periods of colonial rule. Now, these systems work least well in Western Melanesian countries, where hierarchy was far less common, where colonial rule was briefer, and cultural assumption about rulers and rules basically was strong. Now, these state systems in the Pacific exist parallel to customary governance arrangements, which vary across the region. Across the Pacific, you can find governance arrangements formalized through bylaws. You can find governments appointed or endorsed community leaders. You can find community or village governance arrangements overseen by village chiefs, big men, or tribal leaders. You may find established council of elders and other similar arrangements purposed on the maintenance of peaceful, harmonious communities. In many cases, the legitimacy of non-state or customary governance mechanisms supersede that of the state, whereas in others, there is an understood compartmentalization of which domain is better suited to an existing issue. In order to understand these dynamics, one needs to get an idea of the plural justice mechanisms which exist across the region. In many Pacific Island countries, the vast majority of disputes, especially in multi-island jurisdictions with populations away from cities or mainlands, these are resolved by indigenous or other traditional and customary justice systems, and not the official justice system of the state. Often such systems, such as the state, are either simply ignored, or you have traditional justice systems being ignored by official laws and courts of the state. Or you basically have the state seeking to actively suppress them without regards to the impact on access to justice and other rights of local people. Globally, there is increasing interest in the potential role of indigenous and other traditional and customary justice system in efforts to achieve access to justice for all and effective, accountable, and inclusive institutions. Now, indigenous and other traditional or customary justice systems vary widely around the world in their composition, their aims and approaches, their practices, the processes they follow, and the norms they apply. There is often a multiplicity of different such systems within a single Pacific Island state. The degree to which the relationship between such systems and the state system is explicitly addressed in the national constitution or other legislation, and the degree to which actors within different systems recognize in practice one another's role or authority and seek coordination or confrontation also varies. The very diversity of such systems in the Pacific demands considerable sensitivity to the risk of overgeneralization, to implicit biases around justice practices. There are common distinctions such as formal versus informal, for instance. Many themselves embody certain colonial as well as cultural assumptions and biases. Furthermore, state justice systems themselves incorporate a range of traditions and customs, and there is always a risk of confusion between a process that aims at upholding universal rights norms and one that arbitrarily or unjustly privileges some traditions and customs over others. It cannot be assumed that such systems will necessarily operate outside the framework of state institutions and the state international obligations. Sometimes indigenous or other traditional or customary justice systems are either explicitly or implicitly integrated into the national legal order or fall within areas of state responsibility as a result of their operations. Nevertheless, some patterns do emerge in terms of recurring practices and characteristics of many, if not most, such systems, and ultimately, there is value in discussing the issues at a global level, even if the terminology available does not always fully capture reality in a comprehensive and entirely objective manner. The reality for many Pacific Island states is the existence of plural justice systems. There is a general awareness of the existence of these systems, which often work together through, though sometimes they come into conflict with each other. For the most part, state justice systems are made up of the police, who serve as the front line of the criminal justice systems. You have the courts, where decisions are made on matters brought forward. And you have corrections, where persons who have either been found guilty by the court are now awaiting trial or sent for rehabilitation. For some states, there is a fourth layer to the justice system where matters involving, of course, juveniles are handled. As I mentioned earlier, the geographic distribution of multi-island jurisdictions places limits on the ease of accessibility of state justice mechanisms. In most instances, courts and correction facilities are located within capital cities only, with police serving as the only visible arm of the state justice mechanism in rural and remote areas, or as they're described in the Pacific and outer islands. I should also note that police presence is not available in all areas, which necessitates visiting or other arrangements by police representatives. So you also have non-state justice and policing mechanisms in these outer islands, which may include, again, council of elders, village chiefs, communal meetings, and other indigenous systems established to deal with conflict maintenance and peace. Some of these systems operate within established village, community, or island bylaws, which are recognized by the state. And in other instances, there is no recognition of these systems by the state. Allow me to put all of this into context by focusing on one Pacific island state, the small island state or the micro state of Tuvalu. For those of you who are not familiar with Tuvalu, allow me to give you a bit of insight. So I've said much about island jurisdictions and plural justice mechanisms. I'm now going to provide an example of the workings of such a system in one of the 3 Pacific Island states that have been identified as least developed in the world based on the UN's Development Index. Now, Tuvalu is a Pacific Island state located approximately midway between Australia and Hawaii. It is one of 4 Pacific Island states identified by the Development Assistance Committee on the list of least developed countries in the world. The multi-island sovereign nation is comprised of 6 atolls and 3 reef islands. So you have 9 populated land masses, all of which are susceptible to the impact of climate change. Tuvalu has a population of just under 11,000 inhabitants, with a relative balance between male and female. So the nation's capital and central business district is located on the island of Funafuti. It has a population of approximately 6,320 persons located on Funafuti, with the other residents of Tuvalu or the other nationals dispersed across the other 8 land masses. Populations across these land masses go as low as 34 inhabitants in one island, the least populated island, to 300 in the middle most populated island, to over 6,000 in the most densely populated island. The local government of Tuvalu is based in the main island of Funafuti, where the majority of the Tuvalu police service is based. I'll talk a bit more about the Tuvalu police, which is the only visible arm of governance and state justice on the outer islands. So Tuvalu has a council of chiefs, which is comprised of 1 chief representative from each of the 9 islands. On the outer islands, there are village heads and chiefs for each island. The council is made up of all male elders and all male village representatives, and all male family representatives have the responsibility for the maintenance of law and order. State laws in Tuvalu are upheld parallel to community bylaws. So there are state laws and there are community bylaws, which differ across the 9 islands. Each of the 9 islands have their own bylaws. With the exception of the police, all other state-appointed stakeholders, including the court and all legal representation, are based primarily in the central business district. Day-to-day disputes are usually resolved at the family, church, or community level without state involvement. Now, I mentioned there that police is the only visible arm of governance available outside of the capital city and main island. To give you an idea of what policing looks like across Tuvalu. So there are 101 sworn police officers, 94 males and 7 females, serving within the land, maritime, and prison arm of the organization. The officers are distributed across the 9 islands, with 83 of those officers being based in Funafuti, where the central business district is based. 5 officers being based on the island, the second most populated island, either 3 or 2 officers being based on the remaining outer islands, and no police presence on the least populated of the 9 islands. Now, the Tuvalu Police Service has 1 marine vessel or patrol boat, which basically provides support for officers stationed across the 9 inhabited land masses. A lack of resources or availability of modern facilities on outer islands results in reliance on marine vessels for correspondence with police headquarters based in Funafuti. Police stations in the outer islands basically lack resources available at headquarters. Unlike police officers on the main island, officers on the outer island do not work on a shift duty. Rather, they work standard government working hours, Monday to Friday, 8:30 a.m. to 4:30 p.m. They are also required to be on standby after working hours and weekends for any calls for assistance from the community. Now, while police are identified and acknowledged as state-appointed law enforcement officials, their roles are negotiated and navigated to align with the contextual expectations and accepted behaviors on each island. Non-state actors, such as community elders, occupy the primary role in resolving disputes and enforcing community bylaws. So instead of serving as the principal law enforcers, you have police, which is the only arm of governance visible on the outer islands, being invited to provide support by the community leaders as deemed contextually appropriate. Now, in Tuvalu, a high value is placed on restorative justice practices and restitution as deemed fit by the community in consultation with aggrieved individuals and, or in the cases of domestic and family violence, their family, usually the male representative of the household, no matter how young or how old that individual is. So justice in such contexts is primarily focused on appeasing not only the victim, but the close relations, mainly the family patriarch of that victim. Offenses therefore extend beyond the aggrieved, and justice becomes an act to restore balance at the community level. Instances have been documented where the victim is excluded from discussions relating to how justice should be executed or how matters should be dealt with And there have been instances where the dissatisfaction of victims about matters disregarded and compounded by further victimization at the community level. You have instances where state justice, which in this case is the police, are invited to execute judgments made by community elders. In such contexts, victim status is determined by the community as opposed to the statutes or the laws of the land. Someone who commits a crime according to the law may not necessarily be construed as the offender, and a victim in such context can experience further victimization or criticism for disclosure of a crime. Just to put policing into more of a context, as I mentioned, there are, just a reminder, 101 police officers, 7 females, 94 males. There are either 1 to 2 police on the outer islands, with most being based on the headquarters. All police officers in Tuvalu are trained outside of Tuvalu, and prior to 2018, there was no formal training for police officers. So basically, if you decided you wanted to become an officer and there was opening, you can fill out a form, apply, and without any formal training, you would be appointed as a police officer. The state is extending reach by standardization. This is due to external influences and expansion of state authority and the requirement to meet human rights and gender rights. Now, to look further at policing in Tuvalu, bearing in mind police is the most visible arm of the justice system. You have church and customary authority being embedded in the larger system in Tuvalu. You have plural policing and hybrid systems of justice. You have entanglements and interdependence between religious and indigenous authorities. And the changing landscape of relationship between church, state, and customary authority is also an issue for Tuvalu. There is also the issue of religious diversity and the changing place of indigenous authority alongside urbanization, globalization, and professionalization in policing. Now, there have been instances where police immerse into local communities. You have the positives in terms of generalist policing styles, flexible functions, localistic rather than legalistic approaches, but challenges exist in terms of unfair practices, officers being susceptible to influence over and under policing, and basically, as I mentioned earlier, further victimization. Now, in terms of points to note about policing in Tuvalu, Tuvalu is an example of multi-authorities all wanting to be at least somewhat responsible for law and order, and also with an understanding that the outside influences wield power with respect to where justice should be focused. There are important aspects included in the Constitution which allow for religious and cultural authorities to be involved in governance in Tuvalu. And of course, plural justice systems is a functional outcome which allows for the legitimacy that states seek because of respect for tradition as seen as part of a larger process. As I indicated in my example, there are conflicting authorities in such systems where the arm of justice is left to negotiate various power structures. I now move to examining contextual variables that are likely to impact on societal inclusivity, access to justice, institutional accountability, and inclusivity. Now, based on all that has been said thus far, a logical next step would be to further examine contextual variables likely to impact on societal inclusivity, access to justice, and institutional accountability. I propose 4 areas as relevant to such discussion. There is certainly a need to look at existing legislation at the national level. Over the past 5 years, many Pacific Island states have undergone extensive legislative reform to update their legislation so as to align them with international standards and best practices. This continues to be a work in progress for most countries, with policies, standard operational procedure, practices, and re-education processes lagging behind. Reform legislation in the hands of persons not well prepared to interpret and enforce such legislation becomes another pointless exercise in checking boxes. Another point, the justice models can be found across Pacifics to improve how non-state justice systems are recognized and to a large extent formalized. This is certainly a practice to be prioritized on a larger scale and one that external stakeholders and program evaluators and assessors need to be educated on. The examples I've provided today speak directly to a need for greater contextual orientation about crime, about violence, about victimhood, to aid in altered orientations and perceptions necessary for advancement of the United Nations General Assembly 2030 agenda. There is certainly a need for states to rethink how they facilitate the compliance with these sets, mechanisms, and systems with standards of human rights. So I end on the note of why do we need to rethink our understandings of access to justice. Like other research in the area of the impact of external models of justice being integrated into new places, this is one way, either directly from New Zealand and Australia or from Fiji, where they have already adapted models from Australia or New Zealand. Important models should not be done fully. Rather, there should be an examination of the cultural practices that might be in conflict with a standard justice model and alter that plan to fit some of the important aspects which create Pacific solidarity, or some might argue social solidarity. The dominant practice in judicial reform in the global South, where the Pacific is based, has been to follow practices from the global North. This has been referred to by scholars as a larger process of monocropping culture of institutional development that basically ignores the importance of local histories, contexts, and institutions, and that such institutional monocropping has contributed to the failures in development interventions, as well as impacted negatively on legitimacy of the state. Justice reform in small island microstates, such as the Pacific, continues to be underpinned with assumptions about justice working in a liberal, democratic, secular state with Western cultural norms in which the state exercises primary moral authority. These assumptions are also underscored by Northern ideas about justice, which fail to acknowledge state justice mechanisms and the larger governance body to which they belong as imported constructs, which at times come into conflict with older, more established, more legitimate systems of governance, such as those I've described in the Tuvalu context. Assumptions from such external contexts are usually disconnected from the realities in deeply religious societies, and they often ignore specific cultural institutions and values integrated into constitutional and legal frameworks. I leave you with certain points of comparison. Well, before I leave you with my main points, allow me to stress on the key points that should have come up as takeaways. There is a need to not only recognize, but to understand Indigenous forms of justice as critical to meeting Sustainable Development Goal 16. It is also important to understand the nature of such regimes and the interface between state and non-state regimes. The Pacific context demands that we examine variations in level of accessibility to justice mechanisms in multi-island jurisdictions, and cultures, consciousness, and mobilizations are critical to an understanding of the sphere within which justice is practiced and accessed. A pathway towards peace, justice, and strong institutions is therefore, in my opinion, reliant on 4 key areas. They're reliant on understanding island jurisdictions as multi-island spaces with historical complexities, interface with colonialism, recognize systems of governance. Second necessity, mapping. There's a need to map plural justice mechanisms, be it legal plurality or regulatory plurality. There is a need to further contextualize crime, and as Julie always says, varying harmscapes. There's a need to look at what exactly is meant by violence and victimhood in contexts outside of those described or captured in Western ideologies. And lastly, there's a need to examine contextual variables likely to impact on societal inclusivity, access to justice, and institutional accountability. I will end there. It has been 45 minutes. Thank you.
Great. Thank you so much, Danielle. Well, let me just find my clap function. There we go. Okay, you're welcome to switch your videos on again. And if anybody has any questions, please do so. Anybody, if you can remember how to raise your hand. Anybody? Yes, Anna.
Hi, it's been a long time since I've used Zoom because we're all back online in person now, so I've forgotten how to do it. But Danielle, I just wanted to say how interesting that was and how much I enjoyed it, and thank you so much. And I've got quite a specific question, which I'm not sure if you're able to answer or not. I'm just to introduce myself. I'm an ethnographer and I work in small islands in the UK. So I work in the Shetland Islands, which are actually. I was really interested in your account of Tuvalu and what that's like. And I was actually, Shetland itself has got a population of 23,000, but there's people who there are islands very similar in size. So the main islands, the main town's got about 6,000 people in it. There's islands of 8 people, islands of 30 people, and so on. And one thing that really struck me actually was how many police officers there are in Tuvalu. Like in Shetland, there's 37 for the entire archipelago, and so it seemed to be what the role of that police officers is really fascinating to me, because they seem to be a bit more like a kind of a different kind of state agent, and I'm just really curious about what that is. But my question is actually the question of having, I don't know whether you know, whether you, with your researchers incorporated this, but I'm really curious. In Shetland, there are, of course, there's only really 2 islands that have a police presence because of the difficulties in accessibility and the lack of ability to travel and the lack of resources and all kinds of other very local, contextual, cultural issues, which is exactly as you're describing, and a very complex relationship with the Scottish mainland as well, in which Shetland sees itself as a kind of victim of a different kind of colonizing influence from Scotland. So it's all kind of very complicated, and I think you're absolutely right in understanding the kind of local cultures and how they interact with all this stuff. But one thing that really I found really curious is that there are local systems of justice there, but they're not formal. They're all to do with kind of local gossip and the way that communities and islands sort of police themselves because they have to, because there's no state presence. But even there is an odd relationship with the state and the kind of the state mechanisms of justice, in that people feel that that has a status beyond the local systems of justice, so that they feel that they should have an entitlement to formal state justice. They should be able to have access to courts. They should be able to have access to police officers, because they see that partly as it's a kind of complex duality, that on the one hand they see it as something which is separate to them and something which doesn't represent them, but on the other hand they see it as a kind of resource that they should have entitlement to and a sense of belonging and acknowledgement by the state that this exists for them. And I just wondered whether in your research you've had any whether you have any insights or explorations into how those systems actually interact and how they're understood by the people in them. Does state justice, even though it's kind of, in some cases, very marginal to people's everyday experience and is a different kind of justice that people have access to, does it hold a different kind of status or a different sort of meaning to them than the local access, the other forms of local justice, Indigenous justice you're describing?
Thank you for that question, Anna, and thank you for sharing insight into UK's small islands, which of course is absolutely new and exciting and fascinating for me, and something I would like to learn more about. In terms of the what I've seen in my research is different levels of legitimacy of state justice mechanisms based on the strength of the traditional systems on some of these outer islands. So, and the outer islands that have had less interface with formal justice system, there is more of a pushback and a secondary status assigned to the state. So the state is viewed in such contexts as service providers for the communal systems. Now, in the Tuvaluan context, the community elders or the chiefly system is recognized in the Constitution, and each island has its own bylaws. So basically, they rely on state justice or the police, who are the only arms visible on these outer islands, to support with the implementation of their bylaws. For example, on some islands, it is considered an offense, a finable offense, to consume alcohol on a weekend. So if the chief finds out there's drinking of alcohol, the chief would send the police officer to detain that individual or fine them. So you find reliance on the state resources to implement community bylaws. However, there are instances where sharp lines are drawn, where the community deems issues as domestic or the domain of the community. For example, domestic disputes or issues around family land. There is a pushback against state involvement. So this is in the Tuvaluan context. In other islands across the Pacific, it differs. So in some of the more remote outer islands in Solomon Islands, where there are no state presence, the visiting presence of the state to respond during emergencies and disasters. It's something that's not welcome. You also see dynamics in terms of these perceptions as representative of different age groups. So in terms of the last stakeholder engagement survey that was done around looking at engagement with police, you found younger persons and persons who were more exposed, expressing a desire for greater state representation or the visibility of state justice systems in all parts of the islands, whereas there was a pushback from older members of the community that there was no need for it. So you have youth, members of vulnerable groups saying this is needed, and you have the power brokers or male elders saying, no, this is not needed. So it really varies.
Great. Thanks, Danielle. And Anna for the
Thank
question.
you. Really interesting. Thank you.
Great, thanks. Paul, you've had your hand up.
Hi, thanks. That was really, really interesting. I've just got a question about kind of climate change and rising sea levels. I was reading about Tuvalu and the issues that they might be facing, the sort of deals struck with Australia for sort of aid, and I was just wondering how that might affect sort of the future kind of a relationship of state and non-state justice forms, and also that kind of relationship with kind of like coloniality and an imposed justice from the outside. Thank you.
Thank you for that question, Phil. I have not done any research in the climate change space at all. But in terms of the impact of new agreements, so you might be aware from your reading that Tuvalu has just entered into an agreement with Australia that allows Australia certain rights in terms of making decisions related to security of Tuvalu and decisions around security-related issues in the maritime space. And the agreement also allows for a lottery system that facilitates the movement of just over 200 Tuvaluans a year relocating to Australia. So there is a lot of concern about what that means for the country's sovereignty in terms of Australia having rights over security issues, and the movement, a program that facilitates the movement of over 200 nationals from an island with a population that is already dwindling. So in terms of the census, it states that they're just under 11,000 people, but in terms of the reality, it's just over 9,000 that are actually based and living there. So there is that sense of nervousness around loss of the able-bodied working population, and an elevated risk of what happens well ahead of the impact of climate change. So in some instances, you have the measures being implemented as a future strategy to deal with the issue of displacement being moved forward based on this new agenda. So the islands aren't underwater yet, but there are systems in place that allow for movement. And this is not new. There have been arrangements in the past with Fiji, where Tuvaluans secure land in Fiji that allows them to move and resettle there as well. So there have been other measures in place, but in terms of its impact on security and legitimacy of the state law enforcement, the state systems, I am not aware of measures that are specifically related to climate change or related to that particular agreement.
Great, thanks. I mean, we're at time, but I think we can have another question. If people need to leave, they're welcome to go. Marguerite, do you still want to ask your question?
Then I would, thank you. Danielle, I was really interested in what you said, that some of the traditional or local justice mechanisms sometimes also leave the people affected as more victimized, for example, by the community. And that's something that we see in our justice system too. And it's usually the people with the least power have the least good outcomes. I was wondering if you know of any examples where that's less likely to happen, or is it always the least powerful that will get the least out of justice?
Unfortunately, thank you, Marguerite. Unfortunately, all of the examples that I am aware of are examples where you have the least powerful being more victimized by the system. I'm not aware of any examples where there is a toppling of that power hierarchy. So you have members of marginalized groups primarily being further victimized. At the cost of justice is weighed against the impact on the community. So if the perpetrator is the only plumber on the island, then you have to accept some form of restitution, or there needs to be a measure, or there needs to be a punishment that does not punish the entire community. So basically, your victimization is a small cost, is viewed as a smaller cost to the cost that the entire community would pay without that individual. So there have been such arguments, and there have been, I'm aware of one case where a male who would normally be seen as a powerful individual if the victim was not a male was chased off of an island because of differing religious beliefs. So you have those rare cases, but then again, it comes down to the powerful majority making a decision against the less powerful individual.
Great, thank you so much. It was absolutely fascinating. I must thank you, Danielle, for a wonderful talk. It's really inspired a lot of thinking for most of us, I think. So to that effect, I will end the session, and I thank you very much for all of you for your attendance. Thank you so much. Have a good day.
Thank you so much for having me.
Bye, everyone.